The duty to accommodate is referred to as the bedrock of human rights principles. It often arises in cases of physical disability or emotional disability, but it doesn't have to be limited to cases of disability. Accommodation requires an effort from both parties to reach a common goal of allowing the worker, in the case of a disability, to return to work either on a graduated basis or perhaps even to an alternative position. There's an example of a case that came out of Ontario against the city of Hamilton. The applicant in that case was responsible for asbestos issues in commercial buildings in the city of Hamilton. And under the statute, the applicant could have been criminally prosecuted if she did not do her job properly. This caused her serious emotional problems. She was off work for some time due to a disability caused by those emotional issues, and then she sought a return to work. As it happened, the city of Hamilton had other positions available for which it did not consider the applicant. She filed a human rights complaint on this basis of accommodation, that the city should have allowed her to be hired for these alternate positions for which she was reasonably qualified. The case went up to the Court of Appeal and took some 11 and a half years to finalize. Because of the human rights process creates a ticking time clock for lost income, she was ultimately successful in her case and recovered 11 and a half years lost income, virtually $1 million, plus compensatory damages, and was ordered reinstated to her previous position. So it's an example of the nature of the obligation upon the employer to take reasonable steps to adjust this position and try to accommodate the existing disability, even to consider another position. There is another case that took place in British Columbia, where a medical doctor was seeking his license as a practicing physician. His entry into the program was delayed because he had an emotional disability. Again, the issue was, should the government of British Columbia accommodated that and taken reasonable steps to allow him to continue into the employ as a physician, notwithstanding this emotional disability. And he was successful in his case and recovered $385,000 in lost income. So these two cases are prime examples of the need for the employer, and British Columbia was not an employer, it was a different circumstance, but still the same issue, to allow reasonable accommodation to win the day over an existing disability. Again, it's a two-way street. The employee has to cooperate, the employee has to produce medical reports, go through rehab, follow whatever medical advice he's been given to reduce his limitations, and provide full disclosure of all this to the employer. So it's not just a one-way street. And the employee also should be flexible in terms of his or her objectives. He may not be able to return to the same position he had before. There may be some limitations on it. It may be a gradual return to work. He may not be receiving identical income on the return to work. So this flexibility, this duty to accommodate, again, is a reciprocal obligation between the parties. But as you can see, the damage claims can be huge when there's a finding of a failure to accommodate. There was a case in Alberta involving a gender discrimination that allowed $620,000. There was another case in under the federal legislation which allowed 10 years lost income, all due to this failure to accommodate. So it's vital that there's a good understanding of this. You should get legal advice if you have this issue arising. And this again illustrates the huge difference between human rights law and a wrongful dismissal claim. So beware and be smart.